interesting lawsuit you sent me. This one is about a I'll pull up the details in a second, but it's about a legislation regarding counseling and what counselors are allowed to discuss with their patients. Now, when Robert sends me my homework, and sometimes I have no backdrop, I have no context, and so I started reading this lawsuit, which was basically challenging a law that would limit what counselors can advise with their patients, young patients, as relates to sexual orientation, gender identity, et cetera, et cetera. Not knowing anything of the context, I thought that this was going to be, I thought it might have been coming from a conservative state that was going to limit a counselor's ability to discuss these issues in the sense of, the positive affirmation side of it, the coping with gender identity issues. And with, and as I'm reading through this, I'm like, I think I have a problem with this, even if I might disagree with some of the other bigger policy issues about allowing children to do certain things to their bodies. The discussion aspect, I would have a problem with if the government were saying you cannot discuss this when a kid going through it is bringing it up. Then I got a little further into it, and I realized it's the exact opposite way around, where it's policymakers basically saying to a faith, he's not a faith-based counselor, but he is a Christian counselor who says, I want to try to talk to my children, patients about this and help them through it without it going to the next level, which is where people have big problems with it. So when I first thought it was the other side, I was like, okay, well, I still have a problem with stifling free speech. And then I realized it was the other way around. And that's how I sort of can feel confident that I can see it objectively. But the policy effectively limits a counselor's ability to discuss certain things with their patients as relates to transgenderism, homosexual tendencies, beliefs, ideologies, tendencies more so. And it prohibits the counselor from what they called, I think in the lawsuit called pray the gay away, which is one of the old expressions that people use to demonize religious people who tried to, who ostensibly were trying to get people to stop being that way. But this is a Christian counselor who now sees legislation coming into effect that would prohibit him from having certain discussions, not all the discussions, only the discussions to talk a person through it or out of it, for lack of a better way of putting it, as opposed to talking them through it and into it, which seems to be tolerated. And so I hope I've described that lawsuit properly enough, but it's a legislation basically that says you can't discuss trying to talk someone out of it, but counselors can continue to discuss talking someone into it. And so this person, I forget the name now, but they filed a lawsuit on the basis of First Amendment violations. I think it was a viewpoint-based discrimination, in that the lawsuit didn't say you can't talk about any of it. They said you can't talk about part of it based on your viewpoint discrimination. Did I do a good enough job with that, Robert?
Yeah. I mean, basically the state of Washington, in an effort to ban what's called conversion therapy, banned people even discussing anything that could get anywhere close to it. Basically, if you're a counselor and somebody comes to you and expresses anything about sexual identity or gender identity, all you can do is affirm the transition, affirm the alternative behavior. You can't say or do anything that suggests, okay, maybe that's not who you really are. Maybe what you're going through relates to something else. Maybe it's not even when somebody comes to them and says they don't want to have that behavior, or they find the behavior problematic in some other way, or maybe they're, married and consequently other things. So whatever the circumstances may be, in the name of prohibiting conversion therapy, which is really prohibiting religious expression as well, they have basically prohibited any statements. It's two things. There's a prohibition on what you can say. There's a prohibition on what the patient can ask for. And there's coercive, compelled speech. You're forced to say certain things, and the patient is forced to say certain things. So not only are they invading the privacy of a doctor-patient, counselor-patient therapeutic relationship, but they're prohibiting certain speech and compelling other speech. And they've also brought a Fifth Amendment challenge because the standards they have are ridiculously vague. It basically says, if you don't, you better guess what's politically correct. And if you don't, we're going to take your license away.
And here, I'm going to read a passage. I don't like screen share. If people think screen share would be beneficial, I find it boring, but 7.3 thousand in the chat, only 2,000 likes. We can fix that now. But while you fix that, let me just read this section. It says, the counseling censorship law added, quote, performing conversion therapy on a client under age 18, end quote, to the list of conduct, acts, or conditions that would constitute unprofessional conduct to the license holder. Marriage and family therapists are among those deemed to be covered license holders under the definition of the law. Conversion therapy, quoted, is defined in terms that are vague, content-based, and biased against one perspective or point of view, and it defines it. Maybe I'll do it. Conversion therapy means a regime that seeks to change an individual's sexual orientation or gender identity. The term includes efforts to change behaviors or gender expressions, or to eliminate or reduce sexual or romantic attractions or feelings toward individuals of the same sex. The term includes, but is not limited to, practices commonly referred to as reparative therapy. And so what's amazing is, reading the first half of that, you could read that in the exact politically, ideologically opposite sense, that they're prohibiting someone from encouraging someone to change their gender or their identity. It's when you get to the second part of it that it basically says, no, it's the exact opposite. Even if the person comes to you and says, yeah, effectively, help me. I want to be a certain way, or I just want to discuss it and help me get through this. They've tied their hands, and they've tied their hands in the sense that from what the lawsuit alleges, anonymous complaints can be made that can result in the license being revoked from this counselor. Anonymous complaints for non-compliance. I mean, it's beyond thought police. It's almost before that. It's minority report, thought language police, that you can't even get into the discussion. And how are they supposed to treat their patients? And it limits the counselor's speech and the patient's to some extent.
No doubt. It's what we've been discussing for a while, is increasing use by the state of their licensure controls, which are effectively occupational controls, to dictate they become agents of the state to promote a certain ideological point of view, and to do so even in relationships of trust and confidence. So that, you go in, you think you're talking to a therapist, you're really talking to an agent of the state who is being told, who has to tell you which direction you can take. You can't use all the therapeutic options. It's not limited by what the DSM-IV, DSM-V5 says, not limited by scientific restrictions. It's the state saying, no, you can only promote this and you can only discourage that. And that's it, regardless of whether that's good or bad for the individual under the circumstances. No individual assessment either. It's, this is good, this is bad, that's it. Even though there's people who are bringing suit now in the UK and elsewhere on grounds that the advice to transition with the physical treatment, the medical treatment, and medical interventions that went with it did severe harm and violated their informed consent requirements. They're basically forcing people counselors to only recommend the kind of treatment that's getting doctors sued in different parts of the world because of its medically problematic characteristics, because a lot of it is experimental and sort of similar overlap in that context with the COVID public health intervention questions. So it's a suit that should win. It's in the state of Washington. It's a federal court. Who knows? Unfortunately, in those courts, but it's a case that should win because it's compelled speech. It should win just on void for vagueness grounds. When you create rules that you have to guess what they mean, then that's void for vagueness grounds under the due process clause. But it should also be struck down on First Amendment grounds.
And here's another passage. It says, it is revealing to note that the Washington legislature also rejected an amendment that would have specifically exempted counseling that would have been, quote, consistent with the client's affirmatively stated goals or objectives. And people have to appreciate how over the top this is, because this is something that you would have to agree with regardless of how you feel about gender transitioning and all of these other issues, even with kids. Regardless of how you feel about this, to say that you are going to basically limit the professional advice that a patient can get from their professional, their counselor, it's nothing less than that. It is nothing less than saying the counselor has to give you a specific answer to a specific query, regardless of their belief and regardless of their professional opinion. And it's egregious because typically, if a patient is getting advice that they don't agree with, or they don't like, the pressure they feel from their counselor, you go get another counselor, you go get another cognitive behavioral therapist, or you go get another whatever. But to make the therapist basically promote a theory, notwithstanding their professional training, you may as well just be going, like you say, just go to the government. Have a congressman tell you what you should do. It's preposterous. There seems to be no limit, but luckily we've seen the first two cases we talked about today. The courts are setting some limits. This seems over the top, but I say this in Canada, where we know what happened to the father who was protesting his child's gender reassignment surgery at age 12, 13. Made some public statements, defied some defied some court orders, and is now in jail for 6 months for contempt for making public statements about a case, notwithstanding a publication ban and a discussion ban. What do you say? What other states have tried to implement anything like this? Have other states followed suit or not yet?
To be honest with you, I don't know. I know there's some states were discussing it, but until I saw this suit, I didn't realize state of Washington had actually passed it. So the credit for them to fight it. They should win. Doesn't mean they will win, but I find it very frightening, this misuse of leveraging licensures. That's why I'm not a big fan of state licensures in general. Require honesty in advertising. Don't require licensing. I think that for lawyers. I think that for doctors. I think that for everything. Well, let me know. I mean, let any ordinary individual hang out their shingle like it was during the days of Andy Jackson, and I can make my own decision. Ordinary people can make their own decision. And so it's just a way to it was initially a way to inflate salaries. Now, in my view, it's a way to indoctrinate, to use that as like a priest license of the state. And you're supposed to only endorse the ideas the state says you can. And so it's deeply problematic.
It's the state usurping the powers of independent professionals. Hip poopy. My opinion about gender issues is irrelevant. If a person needs professional discussion, the discussion should not be restricted from being honest. There's no question. And it is effectively just now it's the state taking over private counseling. If nothing less than that. What was the thought that I just had 2 seconds ago? Oh, yes, that's right. I was going to say, and as far as bar licenses goes, people should appreciate my Quebec bar license costs, I think it's $3,000, give or take $2,500 to $3,000 a year. That's just so I can practice. Then you got to make that money back to pay for your license. But setting aside that, they tax you so that they can then fund the bar society and pay the salaries of the employees who govern your practice, who investigate you and whatever. We've seen, as far as competence goes, excessively low competence representation from licensed lawyers, and we've seen some amazing representation from pro se litigants and from individuals who do it on their own and learn themselves, who could very well be better lawyers than most certified lawyers. So I've never given it much thought, but you make a good point. It's like, just announce that you're not licensed, that you are self-taught, let people come to you if they want, and then see how the practice works. It would certainly eliminate a lot of the coercion that you see, that we've seen weaponized and politicized.